Hello and welcome to the EDiscovery Red Zone. This is Tom O'Connor from GGO in the Gulf Coast Legal Technology Center. I'm down in New Orleans, Louisiana today. And of course, with me is Marean, Senior Counsel at DLA Piper, on one of his rare interludes in the United States between jetting all over the world. I know you're off to fabulous downtown Prague next week.
Prague at the end of next week.
And you just got back from. Oh,
well,
that was an in-state trip, right?
Yes, just a one-day up to the Bay Area to attend the California State Bar Convention.
Okay, so that's kind of what I wanted to talk about a little bit, was the state of conferences and education. You're going to Prague to speak next week. I'm going to speak at the Losi Palooza, the IT Lex conference in Orlando that Adam Losi is putting on, but that Ralph will be at. And, you know, you and I were talking yesterday about we've got the Masters Conference, we've got the Georgetown Conference, we got the IT Lex Conference, we got more conferences than we know it. Are we educating anybody? Are we really making a difference? What's it all about, Alfie?
Yeah, well, yesterday I flew up to San Jose. I took the ODARC 30 flight up, and so I got to the convention center before I think they were just opening the doors. And through absolute serendipity, ran into Richard Best. Richard is out of the Bay Area. He was a discovery commissioner for the Superior Courts up there, and he has his own website on California discovery issues. It's a good resource. And we having run into each other, managed to sit and have breakfast together. Delightful to catch up with him. But one of the things that we talked about was that we were still talking 15 years later to a lot of folk at an eDiscovery 101 level, and you know, whether or not we were making any progress. So I did a presentation. Perry Siegel, who's the head of the California Law Practice Management section, very sharp technological guy, and I did a panel together, which was sort of on ethics in eDiscovery. And we had, I'm going to say, 120, maybe 130 people in attendance. Okay. And so I asked a couple of questions. And number one, how many were litigators? And I think maybe 85% of the hands went up. And then I asked the hypothetical that should strike fear in the heart of everybody, which is, a client walks in your door, they want to sue the XYZ company, you're going to take the case. How many of you sit down and write a written letter to your client instructing them to hold paper and electronic data associated with this upcoming lawsuit? And I was horrified that out of maybe 120 folks, I think only 10 hands went up. And my comment to the group was, you know, you're standing into professional danger. Mm-hmm. And then I went through the pension committee case and you know, the others that you know, if you read them, it really ought to ring your bell. So I weep for the state of education and knowledge amongst a lot of practicing attorneys. And I'd be interested, I know you've had a chance to talk with various judges.
In preparation for speaking at this IT Lex conference, the Innovate conference next week, I'm on a panel with Judge Faciola, our old friend Judge Faciola from Washington, D.C., and Judge Nolan from Chicago. And both of them reiterated that they are still surprised, if not astonished, at the low level of understanding, basic level understanding. As you said, nobody's expecting someone to come in and be the next David Kessler, right? The next Paul Wiener. These are experienced practitioners who are well-versed in all the nuances of not just the eDiscovery rules, but electronic data, and they've made that their specialty for a long time. But the basics, as as I wrote my latest blog this morning that's going to go out in a few minutes, a column I wrote 3 years ago, read the rule book, Shankopotamus. How can you come into court and not know that? How can you not know what a litigation hold is and what your obligations are? So that's what puzzles me, is that we don't seem to be making a dent. And part of it, I think, is I know way back in the foggy mists of dawn, or actually the foggy mists of evening when I went to law school at a night school, you know, nobody paid attention to civil procedure. That was sort of a first-year requirement, and everybody's, oh, God, I got to take this. And, you know, nobody really reads the rules. And so there's been sort of an assumption that, oh, yeah, EDiscovery rules, I don't really need to pay attention. But we should be past that. It's been 6 years, right?
This data point is maybe just a couple of years old. I think about 2 years old, but the new associate came into the firm here in San Diego, and so I asked her, I said, well, did you have any teaching in law school, and a good law school, about electronic discovery? And she said, why, yes. And I said, oh, wow, that's really encouraging. She said, yeah, I think it was discussed.
I sent a curveball about to break across the plate.
For about a half an hour in one day. Let me put you on hold.
Yeah.
Okay, I shut it off. Sorry.
That's all right. And, you know, that reminds me of the story that Craig Ball tells, and I believe wrote in one of his columns about, there's, you know, great teacher at the University of Texas, great teacher, great school, EDiscovery course, and the, I'd love to know what this guy got for a grade at the end of the year. The student who raised his hand and asked Craig, is all of this stuff really important? And Craig said, well, yeah, that's kind of why I'm here. And then his next question was, what's the bare minimum I need to know to get by? Like an underlying assumption almost on the part of the student that this, oh, yeah, it's a rule, I know, and is it really all that important? So, you know, maybe the fact that we're talking about not just a rule change, but an underlying social change in the way we create and store documents, you know, the definition of a document is changed. Maybe that's what's not quite made the grasp yet, or I know you'll be shocked to hear this, but could it be that perhaps attorneys don't care to pay attention to technology?
Well, you know, I'm wondering, you know, we're blessed in our firm to have a very robust lit support operation, internal. Right. And what I fear is that rather than attorneys taking the lead, we're content to leave it at the lit support level and the paralegal level or the vendor level without the necessity of the lawyers confronting their own educational inadequacies.
You know, I think that's a great point. That's what attorneys have done for years with litigation support software. You know, attorneys didn't really learn summation or concordance or Catalyst or iConnect. They let the support staff run that. And so there's been that tendency, although now, of course, this is a legal issue. It isn't just a technical issue. Mike Artfeld, I heard him say in a presentation once several years ago, this is exciting because this is the first time that the law and technology really do intersect. There are technical issues that are now legal issues. We have to know that. I have to interject, though. You mentioned your lit support staff. I was advised that earlier this week, Lisa Clements of your office was made the Commodore of the Chula Vista Yacht Club. I wonder if you now all have to salute her or run a flag up as she comes by.
There is no doubt that the respect that one has to pay to a Commodore is extraordinary.
I have a Gilbert and Sullivan-ish view in my mind of Lisa walking down the hallway with the HMS Pinafore hat on.
Well, you know, But you know, Lisa is a great example of somebody that has a deep understanding and is an extraordinary resource. But unfortunately, having that available to us sort of enables others to wash their hands of it.
You've become, in parlance of my part of the world, you're sort of codependent on Lisa now to handle all your EDiscovery matters. Yeah, I know. And so I think part of that is correct. And part of that, I think that leads to what has caused some real frustration and annoyance on the part of judges with attorneys coming in who don't really understand it. And so that leading to some sort of qualification in some of these pilot projects around the country of you need to certify that you know what you're talking about.
Well, in my presentation with Perry Siegel yesterday, I did point out, since we were up in Northern California, the Northern District has adopted some very interesting rules and checklists and requirements. You know, one of them is that, you know, bring a geek to court with you. Bring somebody that is going to, in fact, be knowledgeable.
And I'm seeing that down in my neck of the woods, too. Courts in Mississippi and in New Orleans, of course, which again begs the question, then do we really need rule changes if the judges are driving these local rules to implement what's necessary? You really wonder if we need that sort of top-down administrative. We've had more changes in rules due to EDiscovery, and certainly more cases due to EDiscovery than are normal in the history of our profession. So I'm wondering if we don't need to slow down. But on the other hand, the Rules Committee astonishingly has not called me for my advice. I don't know. Apparently they didn't. They lost my number. That's all I could attribute it to.
Clearly.
So, well, great talking to you. I just wanted to catch up on this issue because I think with some big conferences coming up in the fall, and I feel like you said, I feel like we've been talking about this issue for an awful long time. And in the words of the Bruce Springsteen song, that's actually, I'm just kind of sucking up to Judge Fasciola there. You know, one step forward, two steps back. Are we really making any headway here? And sometimes it feels like we're not. But perhaps we are. We're certainly more courses at law schools now than there were 5 years ago. There's some headway being made there. So, and a number of these local rules. So perhaps we're getting there, just glacially.
Yeah. It's the pace, I think, that is doing it. You know, one other data point: when I went into the San Jose airport yesterday, there was a big banner, and I forget who put it up there, but the takeaway of the banner was that the amount of business data is doubling every 1.2 years. And so I suspect that that's only going to get shorter, but it points out that you know, that this e-discovery stuff, it's a non-voluntary revolution. We're either going to have to be foot soldiers in it or quickly become victims of it. And I just think that we cannot effectively represent our clients if we don't get our arms around it, and whether that means relying on lit support or vendors or what have you. But it's sort of just realizing that there's the problem. I need to take this.
It's the Rules Committee. They're calling.
Okay.
Bye. Thanks, Brownie. Bye-bye.